Good evening, everybody. It's Wednesday night, so I'm welcoming you to another edition of Chaz Calenda, Attorney at Law, here on the Coalition Radio Network. I'm your host, Chaz Calenda, and I'll be hosting our show tonight. And as always, I'll be keeping the law above politics. I'm an attorney at the law firm of Inman and Torgy in Coventry, Rhode Island, and I'm also a candidate to be the Rhode Island Attorney General next year in 2022. And we're continuing this series here on the Coalition Radio Network, where we're touching on various legal topics here in Rhode Island and nationally. Tonight, we're going to discuss the so called mask mandate case and analyze the legal brief submitted by both the parent's side and the state, the state's brief being submitted by the state attorney general's office. We'll also discuss some updates on some of the local issues we've talked about here on the show previously. My guest tonight is Coalition Radio host and station management Pat Ford. Pat joins me to break down these issues tonight so you, the people of Rhode Island, can see transparently into just what's going on here in Rhode Island. And I'll just say this again for the record. If you're watching me here on the Coalition Radio Network, please take a moment out of your time and give it a like because they have some great content on here from ranging from the humorous to the very serious, something a little bit for everybody. So I think it's worth giving it a click and a like. So please do that on behalf of supporting me here at Chaz Calenda, Attorney at Law, and the Coalition Radio Network. And Pat, thank you as always for joining me here tonight for another lively conversation.
Just think back a few short months ago. Well, first of all, can you imagine there was a time when you didn't know me?
That has completely left my brain. I feel like I've known you forever.
Yeah, my wife has the same attitude. Yikes! It's what's been astonishing about this show is that we've managed to bridge, if you will, the news cycle and the law, while at the same time remaining true to the mission that is, again, politics left on the roadside, if you will, for what the law is. Not sometimes what we think it should be, not what certain people pretend it is, but what is actually the law. And that goes from shows like tonight where we're discussing issues of the day to, again, look back along the timeline. You'll see shows that focus on what your rights are as a consumer, what opportunities exist for you in small claims court, what to do if you're pulled over for an OUI, all sorts of issues that are real politic, real world, that can impact anybody at any moment in their lives. So it's just been an absolute pleasure to do this with you and watch the audience grow here, because apparently it's becoming appointment viewing for a number of Rhode Islanders, both in and out of, as we say, the legal community. So congratulations on all your efforts.
And it's been a pleasure for me to be able to do it, not just simply to get my message out there, but to help everybody who's interested in these topics, because they're not easy to understand and they're not easy to wade through if you get yourself in the middle of one of them. So I'm here to, thinking as myself, providing a service for people of Rhode Island and anyone of the viewers of the Coalition Radio Network. And speaking of Pat, one of the things you said in your little lead up here was we're talking about, issues that are supposed to rise above the politics, talking about what the law is, what the law isn't, not what we want it to be. And I just wanted to provide viewers of this show who have been watching, perhaps in the last few weeks, a little update about what I've heard recently, as recently as today. I know a couple of weeks ago we had Nicole Solis on to the radio. We were talking about the issue of the controversial books in the North Kingstown public schools and whether or not they constituted child pornography, obscenity, things of that nature. And if you recall, we played some clips of Attorney General Peter Nerona outright dismissing any illegality in those books, dismissing them as any possibility of being child pornography or obscenity. Apparently, something happened between that show and today, because apparently now the Attorney General is interested in investigating, and the state police are too, investigating the legality of these books in the public schools and whether or not they in fact do meet the definition of obscenity or child pornography, which is shocking. I must have missed some earth-shattering news. I think I must have missed some earth-shattering news that would cause a person of the magnitude of our Attorney General, who came out and definitively said there was nothing, there's no there, when he was confronted with those books on the Tara Granahan show, to someone who is now allegedly opening up not allegedly, is opening up a potential criminal investigation into this. Did something happen, Pat, that you would
I
think,
don't know.
between?
I was tied up watching election returns last night. Oh yeah. You know, regardless of where you stand on the political spectrum, if you ignore the concerns of ordinary people, and I always call them in my other lives lunch pail issues, and I'm talking about, in this case, inflation, or what perhaps international relations or war that we might be involved in at any time, you do so at your own risk. If you ignore parents, how can I put it politely? Parents' concern for the welfare of their children, then you face their wrath. And clearly, regardless of where you stand on said political spectrum, a unintended side effect of the pandemic has been to place parents front and center, literally, of their children's education. For the first time in my lifetime, parents literally shared a classroom with their children every day. It might be their dining room table, it may have been their living room, it may have been their children's spare bedroom, whatever. Regardless of where you come from economically, socially, whatever your ethnic or racial background might be, parents around America faced public education over the past year and a half in varying degrees, and most of them walked away distinctly unimpressed. And in many cases, they were appalled, and in a number of cases, they were afraid for their children. The notion that you as an elected leader, and I don't use the word govern, I use the word steward, who have been elected to steward their community's resources, and you would do so at obvious risk of their children, and then, because remember, it's always the cover-up, buddy, right? It's always the cover-up. And then refuse, in the case of South Kingstown, a parent's rights to understand what their children are being taught. You're seeing that reaction firsthand last night in Virginia. You saw it in New Jersey, and you're going to see it around the country until whatever laundry you happen to be wearing, right? Seinfeld says we're always rooting for laundry. Whether your laundry is red or blue or gold, whatever, you are accountable to parents every moment that their children are in your, and I'll use their words, care. Because that is a temporary relationship every day. Ultimately, parents bear the full responsibility and the control, which includes the decision-making and analysis based on real-world information about what's happening with their children at any moment, at any time. And again, it's clear that a number of our elected, and I'll use the term leaders, may have missed that point somewhere along the line over the last 10 or 15 years. So for some people, for some reason, think this is a shock. Why is this all happening now? That's why. There was a great movie, war movie, years and years and years ago. It was called Tora, Tora, Tora. And the final lines of the movie were Admiral, the Admiral of the Japanese Navy, and he said, in Japanese with subtitles, he says, "I fear we may have awakened a sleeping giant." And that's what's happened in America. That sleeping giant is in totality parents. And parents, again, regardless of your background, regardless of where you're from, regardless of where you're going in life, all share that same filial love of their children and will strike back hard. And that's what we saw last night.
And that's it's exactly what we saw. I think that's what drove a state like Virginia, which has been unquestionably trending blue in the last decade, if you're looking at it from a political perspective. And we saw people who have probably been voting blew all their lives fight back, strike back on behalf of their children because of the outrageous, I would consider them outrageous scandals you see going on down in Loudoun County, the school districts, all these issues that have been going on across the country. And it's not just limited in Virginia. They're looking at it here in Rhode Island, and we've talked about it. And I think that perhaps Attorney General Noronha may have seen the light there, the warning lights shining brightly this morning because, as you know, the Attorney General, the two-term incumbent Attorney General of the state of Virginia, fell to defeat last night of a first-time candidate running against him, along with the slate of other Republican candidates who had been running for governor and the lieutenant governor. It's the only one who was an incumbent was the Attorney General, and he was defeated because he put the politics above law and he failed to heed the warning of these parents that we're talking about right now. So, I hope the Attorney General is doing a fair and reasonable investigation because these parents deserve it. And we're certainly going to keep people updated as we get information on that. But I thought it was a remarkable turnaround about face from our chief law enforcement officer of the state of Rhode Island to come out so quickly and now all of a sudden be interested in that issue. So like I said, we'll keep our viewers updated on any developments that we hear from that. But I certainly want to get into our main topic tonight, which is delving into the mask mandate case. We are anxiously, I would say I'm anxiously awaiting the decision of Judge Lanphier in the Superior Court as to whether or not he will grant the parents' motion for a preliminary injunction enjoining the state of Rhode Island from enforcing its mask mandate on K through 12 students throughout its public schools here in Rhode Island. Both sides, the parents and the state of Rhode Island, and when I say the state of Rhode Island, I'm talking about the Attorney General who is representing the state of Rhode Island, have submitted legal briefs in support of their positions as to why or why not an injunction is appropriate in this case and the legal authority for the court to do so. And I wanted to talk about some of the strong points and the weak points on each side. And I think I'll start with the parents. They submitted theirs first.
Could I jump in for a second and make a request?
Sure.
Because for a lot of us, and the brilliance of this show is that there are so many issues which you're able to make accessible to us. Taking some very technical surroundings and putting it into common parlance. But could you break out for us, when last we visited this per se, I had the opportunity to videotape a great deal of the cross-examination of the state's star witness, Dr. Jim McDonald, and share that with the public, and I'm grateful the court system for allowing me to do that. It was a remarkable moment for me personally to be that close to that type of drama. And there were a couple of Perry Mason moments, and I recommend watching particularly some of the highlights if you don't have the time to do the deep dive like Attorney Calenda does. But we had the testimony, we had the cross-examination, and then we covered the, if you will, the plaintiffs, if I'm using that term correctly in this case, deposition, statement, brief, and then we're going to talk about this. What is the process on a transactional basis? We start with all the testimony. We're all familiar with that. They cover that in Law and Order on TV. These next steps, what's happening?
So what the plaintiffs did, the parents in this case, they asked this court to stop the mandate, basically issue an injunction. And that's the technical legal term for basically a restraining order, asking Judge Lanphier of the Superior Court to stop the state from enforcing this mask mandates on the students, the K through 12 students in public schools. Under Rule 65, I believe it is, of the Superior Court Rules of Civil Procedure, the judge did not have to take testimony. The judge did not have to do that live. He could have simply relied upon affidavits, briefs, and oral argument to just make the decision. But Judge Lanphier, I think wisely, allowed the sides to present witnesses, testimony, exhibits, and obviously the testimony of Dr. McDonald played a huge role. And I think that's going to be one of the things that is going to damage the state's ability to succeed. I'm not saying that's going to be the be all end all, but if anybody who watched that testimony that you had the opportunity to record, Pat, Dr. McDonald was anything but a stellar witness. And, there were certain things that were caught on video where he had to backtrack, or he admitted he didn't read studies, doesn't consider them, whatever it was. There was a multitude of those type of moments, which he referred to as the Perry Mason, some of them as Perry Mason moments, that made Dr. McDonald a less than desirable witness for the state of Rhode Island. And I think that is going to cut to the issue, that one of the issues that the parents raised in their brief, which is that the decisions being made by the Department of Health and the governor, in some respects, are being made almost irrationally, being made in contravention of actual science, not the science that the state wants to use, but they're not even considering that there are other peer-reviewed or other gold standard studies out there that seem to be in conflict with what the Rhode Island Department of Health believes to be the the good science, for lack of a better term. And I think that his testimony and the effective cross-examination of Dr. McDonald is going to play a big part in whether or not Judge Lanphier finds that the Department of Health has a rational basis that will survive judicial review in this matter, when he's looking at whether or not the regulations put in place are serve a compelling state interest and are narrowly tailored enough so that they don't unnecessarily trample on constitutional rights or other state law. So that's one big issue that is that the state is facing. And I would say that the other strong point that the parents made, one of the other strong points, I should say, there are many. One of the other strong points that the parents were making were that it's been going on. This emergency has been going on for such a long time. We've been living under effectively a state of emergency for almost 2 years, and to not have an effective ability to review what the Department of Health and the governor has done during that time, and the regulations being put in place, people losing their jobs, people having to decide whether or not they're going to send their kids to school in masks or have to homeschool or take their kids out of school, and not have the ability to review that is a problem under a separation of powers theory. And the separation of powers theory really is each branch of government, the executive branch, the legislative branch, they each have their own rules. And the state of Rhode Island says the courts, the judiciary branch, has no role here. That was their primary argument in their brief. They're saying that they said the part out loud that we've all been saying, we being people who believe in civil liberties and constitutional rights. The state of Rhode Island said it out loud in their brief that this is a political issue under the political doctrine, under the political issue doctrine, and that courts have no business getting involved in second guessing state agencies when it comes to these types of issues. And they should abstain from doing so because the courts lack judicially manageable standards to review these things. Basically, piling on what in federal court would be referred to as Chevron deference. And Chevron deference basically refers to a long-standing federal case where federal courts are required to defer to federal agencies in the interpretation of their rules, and as long as they're rational and explicit, the federal courts have been loath to get in middle and second guess these agencies. And the state of Rhode Island is asking the courts here in Rhode Island to adopt just that. The problem there is that if there are no judicially manageable standards, then you run into a problem of non-delegation issues. And non-delegation means issues mean that um, the legislative branch, when they delegated to the executive branch the ability to declare these emergencies, or the Department of Health the ability to promulgate these emergency rules, they have to put in place standards that these agencies must follow, and there must be reasonable uh, safeguards in place to prevent administrative abuse. So, by saying that this is a political issue with no judicially manageable standards, they're almost assenting to the fact that there are no guardrails in place to prevent the administrative abuse. And I think that's an important point to make here, Pat. And I know it kind of gets into the weeds here, but their reliance upon this so-called Chevron deference is one that has certainly come under attack by the United States Supreme Court recently, particularly the current makeup of the court. Justice Gorsuch, in particular, had indicated that if we're going to defer to these executive bureaucracies, then there's a big problem with the separation of powers issue, because that was not the way the Constitution was framed.
Particularly in the state of Rhode Island, separation of powers should be not an alarm bell, an alarm bomb that is that should be a smack in the face, if you will, rhetorically speaking, because that has been the singular struggle of this government for years now, is ultimately working on the separation of powers. And when we see essentially an admission by the state that the singular most existential crisis that we've faced as a state, really having to go back to RISDIC, and augmented by the terrible loss of life, it is breathtaking. Mm-hmm. How can they be so damn cavalier?
Well, I'll tell you why, Pat, and just to be bluntly honest with you, is because Rhode Island has no checks and balances in its government right now. You have, and this is not me being partisan. This is not me being political. This is just stating the obvious. This is just stating the reality. The Democrat Party controls every lever of government within the state of Rhode Island, and that includes every state level executive officer, the governor, the lieutenant governor, the secretary of state, the treasurer, the attorney general. You're looking at every single one of them as being those positions currently held by a Democrat. The Democrats hold supermajorities in both the houses of the General Assembly, the State House, the House side, and the Senate. So even if the governor were to come to his senses and say, and try to veto some sort of bill that was passed by the General Assembly, they could easily override it if they wanted to. And then you have the courts, which is supposed to be the independent branch, the non-political branch, the apartisan branch. But in Rhode Island, the judges are appointed by the governor with the advice and consent of the Senate. And like I just mentioned, the people who compose those offices are all of the same mindset. They're all of the same political persuasion. So you can imagine, given the polarization, not only here in Rhode Island, but in our national environment here in the United States, that the judges being appointed who are overseeing these cases certainly have a political bend in order to get those positions. So we have seen a complete lack and breakdown of the separation of powers and ability of our officials to do their job and separate their powers because of that reason. There is no check and balance. The Attorney General has the ability to be that check and balance because he is an independent constitutional officer with a tremendous amount of constitutional authority. He chooses not only not to exercise that, he is choosing to fight against the people seeking that check and balance by defending these these mandates.
Just anecdotally, and I'll just keep this oblique, and I'm almost not asking you to comment. There was a case within the last year that was Corona impacted, where literally an appointee of the former Governor Raimondo was fast-tracked right into it, and shockingly, the very case that she had heard was within minutes essentially dismissed, if you will, from the court, in the form of highly questionable rulings that were clearly politically motivated. I think you know what I'm talking about. We've got this fast track from the halls of the Democratic Party directly into some of the most sensitive litigation this state has ever seen. And many of these jurists are, again, in lockstep with the prevailing wisdom, and I'm using that term loosely, I'm using the coalition air quotes, of the administrations that happen to be in place at that moment in time. Is it possible? Judge Lanphier has been very impressive, and we all understand that it may go one way or may not go another way. Been very impressive to at least to a civilian like me in the manner in which he's conducted this case. Are there a lot of judges like that, or is he just sort of a shining example of the way things should be?
Well, I've dealt with Judge Lanphier a lot in the course of my 15 years practicing law, and much of it's been in the criminal realm, but in recent years, Judge Lanphier has been hearing a lot of the civil cases. I can tell you that Judge Lanphier is always trying to look to do the right thing, trying to understand the situation, and try to come out on the side that he believes is supportive of the law. I can't say I always agree with the decisions of Judge Lanphier or any judge for that matter. But I certainly can see that he is struggling with a very difficult issue here. And he is in the unenviable position of being thrust into this litigation and having to make a decision which he knows one way or the other, whoever wins this decision, they're going to appeal it to a Supreme Court that may not agree with him, that may, I'm not saying will, but may very well be influenced by politics and their own political bends. People can say that Judge Lanphier himself may be influenced by his own politics or what his perceived politics may be. Obviously, he was appointed by former Governor Kachiri back in 2003. So you'll have his critics saying that if he grants this preliminary injunction, he's doing so because he was appointed by a Republican governor. And I don't think it breaks down that neatly, but you cannot help but wonder that the reason why these edicts are still in place or there has been no meaningful check and balance on any of these mandates that have come out is because the judiciary's 100% I would say abdication of their role to interpret the legality of what's going on. And I think there was when I was talking about that Chevron case early on about this, there was an individual, Mark Holden, he was of the Freedom's Partners Chambers of Commerce, had argued that the Chevron deference, the same deference that they're using here in this case, violates the separation of powers, it weakens the judiciary, and it biases court proceedings in favor of the government. And I would say that that's exactly what's going on here. If the state of Rhode Island it prevails in its argument that the Department of Health is entitled to all due deference, even if their decisions may not always be valid, and if their regulations may not always be correct, as long as they're rational, this court has no ability to review them, and that just absolutely, departs from the duty of a judicial office under all aspects of judicial review. It's the court's duty to determine whether or not these agencies are acting in conformity with the law. And I think that's going to be a strong argument for the parents to say, this political question doctrine that the state asks you to dismiss this motion on is a way for you to avoid ruling on the merits and keep their version of the status quo in place. And that would be, in my view, a dismissal under that wisdom, or that situation would be a travesty of justice.
So let's get to the briefs then, if you will, before I
Sure.
diverted you for 20 minutes. Oh man, I'm always impressed by your show organization walking into this, and then when I come in as a guest host, I usually lay waste to that within moments.
No, we've talked about a lot of the issues. They're just having that conversation, though, Pat. We've talked about a lot of the issues that were raised in the brief, and that I talked about one of the strong issues that I think that the parents have, in addition to a lot of the speculative testimony that Dr. McDonald made. Now, I think where the parents are going to have a problem, and again, I wasn't there for the proceedings. I only watched what was able to be recorded and read the briefs as they're submitted. And you read these two briefs, and it's like they were watching two separate hearings. And I'm just pointing this out as somebody who practices law, who writes briefs like this, and after following a hearing and tries to sum up what happened. You read the parents' brief. Dr. McDonald and the state overstate things that are simply not true. You read the state's brief, and the parents are stating things that were not entered into evidence. And if that's true, that's a problem for the parents. There's several footnotes on there that indicate, well, the parents make an argument relying on exhibit so-and-so, but that was actually not entered into evidence, so that can't be considered. And technically speaking, that's true. And I think that's a problem the parents may have to face. So you have a completely different version of stated facts in each one of these briefs that each side is relying upon, and the judge is going to have to be the independent arbiter to determine what the actual facts that were presented in the hearing, which were admissible and actually admitted into the hearing. In order to make that determination, the judge is going to have to do some serious sifting through that. So that's one issue that I'm looking at from the parents' perspective. The other issue is one that is going to be quite frankly very difficult for the parents to get around, because even if you give them the issue that Dr. McDonald was a bumbling mess up on the stand, and I think they'd be very hard pressed to say that he wasn't. Even if you give them that issue, even if you give them the issue, the governor necessarily is trying to, the governor's doing an end run around the budget amendments from the budget passed this year by declaring a new state of emergency based upon the Delta variant, and that executive order therefore is invalid. Let's just put that aside for a minute. The state of Rhode Island raises a good point, and I have to I have to say at this point, the state of Rhode Island, I didn't see anything that rebutted this. They're saying, independent of the governor's powers, the Department of Health properly promulgated emergency regulations when they required this masking mandate through their emergency regulations, which are found under Rhode Island General Laws 4235 2.10, which provides that if the agency finds that there is imminent peril to the public health, safety, or welfare, or the loss of federal funding for an agency program requires the immediate promulgation of an emergency rule and publishes in record with the Secretary of State on its agency websites reasons for that finding, without prior notice or hearing, they may promulgate an emergency rule without complying with the Standard Administrative Procedures Act. And that's exactly what they did. This mask mandate is promulgated under that emergency rule. And those emergency rules are, by statute, can last up to 120 days with one 60-day extension. So really, a total of 180 days. And if this was promulgated on September 23rd, which it appears to have been, that would be at maximum 6 months from that. So, I'm a lawyer, so I'm terrible at math. So we're talking 10, 11, 12, 1, 2, 3, March we're talking about March 23rd, where that emergency regulation would run out if there's no other authority looking at that. So that is one issue that they're going to have to get around. And the other issue I would say that the parents have to get around is just the issue of having an injunction issued against the state. You have to meet those four criteria: the likelihood of success on the merits, the irreparable harm, the ability to maintain the status quo, and the balancing of the equities in this case. And if they're applying, if they simply look at the issue we just talked about with the emergency regulation, it's questionable as to whether or not the parents can succeed on the merits. And if you don't get past that first prong, the other prongs are useless.
Let me
Now,
jump in for
yeah,
for a second. All right, just to refresh for folks who are watching or listening or meeting Chaz virtually, if you will, for the first time, you've got 12 years experience as an attorney in the Attorney General's office as a prosecutor at a very high level. You've also got a few years under your belt as a lawyer in private practice, doing a variety of styles of cases ranging from civil to criminal law. Have you seen examples where where individuals suing the state have been able to be successful in blowing up or granting an injunction like this? Is there much of a track record there?
I mean, sure, depending on issues. I mean, we're in uncharted territory as far as what COVID has brought upon us as a legal system. So I can't say I've seen it in this context, but certainly when there has been blatant violations of civil rights, the government has been enjoined, can be enjoined, should be enjoined from enforcing whatever regulations there are. And many times there is always a judicial review of administrative determinations, whether or not it starts at the administrative level, where you have perhaps an administrative agency like the Department of Health finding in an administrative setting somebody violated their regulations, and then it goes to the Superior or Supreme Court and is reviewed, and they are reversed or find that they exceeded their statutory authority. So it does, in fact, happen. But you are, what the parents are asking here is is a heavy lift. I'm not going to sugarcoat it. It's a heavy lift because there is a determination that has to be made by the governor, and it depends. I'm not by the governor, by the judge, and it depends on what A lot of this depends on what he's looking at, not only as what the issue I just mentioned with the emergency regulation. Let's say he gets past that. What exactly is the status quo? The parents argue the status quo was what it was prior to the executive order. The state argues what it is currently, which is the mask mandate is currently in place. So even if assuming the judge finds that there's a likelihood of success on the merits because the science is shoddy, Dr. McDonald gave some horrific testimony, was contradicted, didn't bother looking up all the studies that the plaintiffs brought to his attention. The plaintiff's science is better, whatever it is. Let's say we get to that step. What's the status quo? There's another step. How do they define that? So there's a lot that goes into this, and it's not just the science-based part of it, which I think the parents, have made a very strong showing on with their witnesses, Dr. Boston. I think they made a very strong showing that their science is just as good, if not better, than what the state is offering. Considering the state continues to move the goalposts on where we are scientifically speaking at this point.
I have to ask you, from a layman's perspective, it just seems like, and I'm talking about everything from qualified immunity for law enforcement to the extreme steps you have to take in the case of negligence on behalf of the state when there's bodily injury, bodily harm, to situations like this. Did the founders intend for the state to essentially be nearly entirely above the law?
Absolutely not. And in fact, the founders, if you look throughout the Federalist Papers, you look throughout the time period where the Constitution was being written, the founders wanted a decentralized government. They were very big on the federalism aspect. So the states individual states having their own say, not having a all-encompassing executive branch like, they were trying to get away from, if you remember in our history, and I know we try to erase history these days in some areas, but if you look at it, look at history of how this country was founded, we were escaping a monarchy. We were
Right.
escaping a monarchy where there was no representative government. You had top-down rule from the monarchy, and the founders certainly did not, and I don't believe envision a government that had such wide-ranging and wide-reaching power that there was no way, or there was very little way, to put them back in their place. I mean, if you think about it, Pat, what the founding fathers were doing by creating this country, they were committing high treason. They had they lost the Revolutionary War, they would all have been hanged.
If we maybe could remind our legislators and our the Solons of our court that I think this year is the 706th anniversary of something called the Magna Carta.
Oh yeah, the Magna Carta.
Isn't that ultimately one of the foundations of what began as English law and ultimately became American system of jurisprudence? Isn't that the foundational document? Wasn't that put into place for some of these same abuses?
It was, and it's a lot. It's a base. That is, one of the things that our government was based upon. A lot of the tenets that are contained within the Magna Carta were things that this country was based on.
806th anniversary, by the way, 806th anniversary. So it's taken them what 250 years or so for Americans to manage to talk about erasing history. Holy cow!
It's a scary aspect because we have, you look at this case, and obviously there's a lot of implications here for this case, and I really do hope that, and I'm fairly confident that Judge Lanphier is going to give this a very thorough review. I certainly hope it comes out, if you're asking me from a liberty perspective, and from a perspective of not having an all-encompassing executive branch that's basically operating by executive fiat at this point without any legislative authority, any legislative oversight whatsoever. I think that the right way to come down from an equity standpoint would be coming down on the side of the parents. You look at it from a legal perspective, there's a lot of roadblocks that you're going to get through. And I think, Attorney Piccarelli has done a very good job at pointing out, the big problems with what's gone on these last 2 weeks. I'm sorry, 18 months. I get that confused a lot. Wasn't it 2 weeks to flatten the curve? But it's
right.
I don't know.
Well,
2 weeks to flatten the curve.
By the way, it was 900. I just PolitiFact myself. It was 906 years ago. So we're going on 1,000 years, folks, of history at this point. But the other question I've got to ask is that up until 2 years ago, or whenever it was it happened, Rhode Island's governorship was traditionally lumped in with Texas as being two of the constitutionally weakest governorships, for lack of a better term. How did that get? It strikes me. Something I haven't done a review on, it would be fascinating to see, is how many states are still operating under a state of emergency here in the United States. Just how many of them are still attempting to find new emergencies. I have this mental image of folks scurrying around the website, wow, the State House right now, trying to figure out new ways to have a new emergency. Have you seen any reference to how many states are still doing that? And at what moment did the governor of Rhode Island become a monarch?
Just anecdotally speaking, you're looking at states that are, in a constant state of emergency, have the most onerous restrictions on liberty and onerous restrictions on their people. being states that are overwhelmingly Democrat voting in nature. You look at the state of California; they've reimposed indoor masking requirements for pretty much everybody, vaccinated or not. You have these are the states that are doing that. You have states like Florida, which has seen a market decline, not only in deaths and hospitalizations, but in cases over the last several months, and they have no restrictions in place. In fact, they've banned local governments and local authorities from putting a lot of these restrictions in place that we see here in Rhode Island. The Florida was the punching bag for a little while because they had looked at Governor DeSantis making sure that the state government was not getting in the way of people's lives, people's businesses, people's livelihoods. And they were saying, oh, well, look at, they're going to get a spike. They had this big spike of cases. Now they're looking at Florida's got some of the most market decline of all of COVID numbers throughout the United States. And they've got probably the fewest restrictions out of almost all the states in the United States. And you look at a place like Rhode Island, Governor McKee came out today, said something like 83% of people are vaccinated, fully vaccinated in the state of Rhode Island, with 90 something at least partially vaccinated. What is the emergency that continues to necessitate the Emergency Powers Act that are given to the governor, that we cannot go about our lives as everyday people without the government telling us what to do? What is the imminent peril? What is the imminent peril that prevents us, the people, from making decisions that are in our own best interests at this point, that we need the government, the governor, essentially, the Department of Health telling us what we can and can't do? I don't see it at this point. I'm not saying the Delta variant, it's not a bad thing. I'm not saying it doesn't exist. I'm not a denier. I'm not an anti-vaxxer. I'm not any of these things. I'm asking objectively, why are we under a state of emergency at this point for the same thing that we've been under since this started? We are in a markedly different place than we were in March of 2020. We have much more information. We have 83% of our population vaccinated, which at the very least, whether you like the vaccines or don't, you can probably all agree that the vaccines are at least effective in keeping the severity of an infection of COVID low. So at least you got that going for you right there. So even on that basis alone, I think that you cannot just simply say COVID-19 or some variant of it exists and that necessitates an emergency that's going to keep going on and on and on until we get to some yet unknown benchmark, and then I'll take away all these emergency rules. This is why we have courts. This is why we have judicial review, because at some point when you have a legislature that's not doing its constitutional responsibility of checking and balancing the executive branch, and it's just basically throwing its hands up and saying, we're not going to do anything, the only other place you can turn to is the courts. And they've done that. The parents in this case have done that. And we're anxiously awaiting to see what the courts are going to do. And obviously it's not just this situation. We've got the federal court situation playing out with the vaccine mandate. I know we've had many healthcare workers throughout the state of Rhode Island and other states have lost their jobs, lost their livelihoods, even though they were working their butts off during the height of the pandemic, and now they find themselves without income. I know that one of the individuals, Paul Rihanna Jr., who's running for governor, I know that he has been very vocal on this. A person who's a CNA himself has lost his jobs, unable to practice as a CNA. And he's been very vocal in the public, confronting the governor about that this overreaching mandate issue. I know he's having a town hall meeting on Friday at 1 p.m. At the State House. So I think people who feel strongly about this issue, if you can make it there, that'd be a good sounding board for those of you who are very concerned about this government overreach. And I'm concerned about it, and I commend Paul for his bravery in standing up to the machinery here, the machinery of the government here in the state of Rhode Island.
Yes, the apparatchiks running the apparatus, if I can harken back to Soviet era America. We're going to throw up a graphic right now. I think we're going to try. This is actually from the National Academy for State Health Policy. Talk about a party, eh? Let's make sure we hit their convention. Yikes. What's fascinating to this, this is the miracle of the internet, right? These are the number of states that are still actively engaged in some type of emergency order. And the ones in the green, the pretty green, or the bilious green, depending on your perspective, are operating it. Connecticut and Rhode Island appear to be operating as the only ones in New England operating under emergency orders. And fascinating enough, you go out to the far west, and it's almost all green until you get to the Rocky Mountain Midwest, if you will. And so it's that's for folks listening. It's a fascinating site. It's nashap.org. Again, the National Academy for State Health Policy. So clearly, and one of the challenges of harnessing this information is understanding the constitutional backdrop at each of these states with respect to the legality of the individual motion. So you have this patchwork quilt, if you will, of state laws which render it nearly impossible for any national organization. You think of people like Goldwater who might challenge this to adopt it in any sort of single thrust. You've literally got to tell your legal argument on a state by state by state by state by state by state basis, which of course, and here is the dilemma, isn't it? In order to harness, if you will, and I hate to use the word attack, but to harness a challenge is probably a better word, against the states, you've got to have the resources nearly of government itself. Mm-hmm. Because from your perspective, as someone who's worked on an intense legal level on both sides, working for the state and then defending folks against the state, is it the state becomes such a monolith that it's nearly impossible to, if you will, fight town hall?
It takes a lot of money and it takes a lot of intestinal fortitude to be able to get that done. And it's no easy task. I mean, for the reasons that you just stated, you cannot just you cannot just have a blanket challenge against all these states, because we've seen it play out in multiple different states. Each state has slightly different emergency laws that they give either their governor or some legislative body in some cases, and that you've got to kind of go state by state and attack each one of those individually where their laws allow it. And in a state like Rhode Island, I think that they've got there are ways to do it, and one of the ways that I think that it would be most successful, at least in the state of Rhode Island, was that a budget amendment that they made this year did to the contrary of what the state wrote in their brief. The budget amendment did contemplate shutting down the executive orders that had been in place prior to the budget being passed. It did contemplate shutting down all of them, and it did, in fact, shut down all of them. And the state leaves that out in their brief. And they say, that budget amendment did not curtail the governor's ability to issue proclamations of emergency. And that's correct, but it did shut down the prior COVID orders. So I think, the state was being slightly disingenuous when they say that the budget amendment had no effect on the governor's ability to continue to declare emergencies related to COVID, because the legislature did speak specifically to those executive orders that did have to deal with COVID. And the governor himself expressed some skepticism when he was issuing these orders that they may not pass legal muster in the courts if they were challenged. So that's one area that I specifically picked up in the state's response, that they were, I think, a little less than candid with Judge Lanphier with their interpretation of what the budget amendment did to the governor's emergency authority.
And if I could, we begin to close out here. A couple of things, if I could toss your way, and I'd love your reaction. First of all, both in honor of your efforts back in the Max Jim case. Let's not forget that. It seems like so long ago, right? And
like a year.
Yeah. And now with Attorney Picciarelli, we need to remind ourselves that the two of you have single-handedly taken on a legion of lawyers. I mean, how many attorneys, roughly, would, if you were to guess and make an educated guess, are working on behalf of the state's case in the masking case?
Well, I saw at least 4 entered. I'm sure there are more that are actually working on it. I can tell you in the case that I had with the Max Fitness case, there were 6 entered against me. 3 from the
Jesus.
Attorney General's office. 3
Your
from the
tax
Attorney
dollars
General's
at work.
office. Yeah. 3 from the Attorney General's office, 2 from the Department of Health, 1 from the Governor's office. I think that's I'm not sitting here tooting my own horn, but it's a credit to myself and Attorney Picciarelli that they feel like they need to throw those kind of resources at us, us little people here who don't have the resources of the Attorney General's office defending everything that we do.
Right. And we need to remind folks, and by the way, there is a fundraising effort going on behalf of the masking folks, which I will share with people on our Facebook page, that folks who are interested in this can contribute. And I want to point out, and this is from the folks in the masking case, that no contribution is too small. They understand that individuals are struggling around the state. On the other hand, I would like to remind people that this case is personally financed by a group of individuals and a group of donors who are having to finance a fight against an entire state institution. My last question for you, and feel free again to continue to deliver information, but if there was a point in time under the leadership, if you will, of one Nicholas Mattiello, where the very notion that the executive branch of Rhode Island government would reign over the legislative branch would have been laughable. And yet he allowed it to begin, and the current speaker, Mr. Shikachi, all right, seems quietly content to allow it to continue. And I find that stunning because in my entire political experience, which is sadly rather detailed, in my entire experience as a resident of Rhode Island, I had never seen the executive branch just so thoroughly control the reins of government and, well, as importantly, the pocketbook of the government. Any thoughts on that?
Yeah, as a long-time native Rhode Islander myself, we were always told, and it's always been seen, at least up until part of Mattiello's reign as Speaker, that the Speaker of the House was the most powerful person in the state of Rhode Island. Right. And it was true for the most part. If you look back throughout our state's history, until COVID hit, really, until COVID hit. And now all of a sudden the governor's found this sweeping emergency authority, which the General Assembly seems all too happy to let the governor and the Department of Health manage without any input from the legislature, despite the protestations of some. Certainly Senator Jessica De La Cruz and some of the members of the House and Senate Republican caucus have been very vocal about that. But realistically speaking, they have no ability to stop these executive actions by themselves because the Democrats have the supermajority in the General Assembly. So, you're looking back at the days of John Harwood as the Speaker of the House, Billy Murphy as the Speaker of the House. Even prior to that, I mean, Matty.
I'm going to throw out a name here from the past, Joseph DeAngelis, who was coined, and I believe it was by Philippe and Jorge, a.k.a. one of the comic geniuses in all of Rhode Island, Rudy Cheeks, named Joseph DeAngelis the Prince of Darkness. And, I don't think the Prince of Darkness ever held a press conference, and I don't think he ever thought he had to seek counsel or counseling. The Prince of Darkness ruled with an iron fist from a top high above, all right? And I'm convinced that the highest point, if you will, both ethically and philosophically in Rhode Island government, of course, we're talking about the Rhode Island landfill, somewhere Joseph DeAngelis, if he's still with us on this mortal coil, is rolling over in, well, according to many, he was always the undead, rolling over in his philosophical grave. So, Joe, I think Mr. Shikashi, I think Mr. DeAngelis might be on his way for an intervention, even if it's from the afterlife. Wow, we've come full circle here. I'm not going to ask you for a prediction. I'm not going to put you on the spot. I want this process to continue. My understanding is that it continues, if you will, in judge chambers, that there are additional proceedings that are taking place that are not typically part of the public domain, as in the natural order of litigation. Those are taking place probably as we speak. And at some point, and I guess this is the unknown, right? At what point does the judge issue a decision? Is the executive order in place, I believe, goes through February. That's what I've been told. Do you think there's a sense of urgency there?
I would certainly hope so. I think that Judge Lanphier is certainly feeling the urgency. I would hope he is, because the governor has shown no qualms about extending all these executive orders. The Department of Health has their emergency regulations until March. So, and this is what they're challenging. So, I mean, it's whether the judge issues a written decision or issues a bench decision. It remains to be seen. I think Judge Lanphier will probably issue a written decision because it's likely to be appealed one way or the other. So, I would hope that we see that within the next few weeks, because these are questions that have to be answered, and the longer it gets put out, the more moot it may become, because things may change again. Because we've been looking at it. Look at it, Pat, for the last almost 2 years now. I mean, things have changed almost on a monthly basis when the government finds it convenient to change them.
Wow. What a tangled web we weave here in Rhode Island, particularly up there at Smith Hill. Mordor, a.k.a., again, the comic genius, Rudy Cheeks. All credit to him, the king of Rhode Island political economy, if you will, Halitosis Hall, which will always be my favorite. And by the way, I think Rudy Cheeks and Philippe and Jorge are still being published, I believe, in Motif magazine. Please drink in their comic genius. I'll just say that. All right, my friend, I think take us home.
Well, as always, it's been an enlightening discussion, Pat, and I appreciate you. I appreciate your insight, and I appreciate being able to provide my insight to everybody who's watching here on Chaz Calenda, Attorney at Law. Again, for those of you who don't know me, I am Chaz Calenda, and I work at the law firm of Inman and Torgy in Coventry, Rhode Island. You can find me at 401-823-9200, 1500 Nooseneck Hill Road in Coventry. I practice mainly in the areas of criminal defense law, constitutional law, and some civil and some administrative and civil law, depending on the issues. I'm also a candidate to be the Attorney General in 2022, trying to unseat incumbent Attorney General Peter Nerona for putting his politics above the law. You can find me in my political campaign at chas4ag.com. That's CHAS, the number 4 at number 4AG at chas4ag.com. And you can follow me also on any social media network like Facebook, Twitter, Instagram. I have all over the place. I have my website. Feel free to reach out to me at any time. I'm happy to give my thoughts and opinions on not only these kind of issues, but any sort of legal issues you may be running into. Pat, again, as always, I appreciate your input here tonight. I appreciate you being a guest on the show. I encourage everybody to check out the content on the coalitionradionetwork.com, and I look forward to seeing everybody on the next edition of Chaz Calenda, Attorney at Law, on Wednesday nights, 8:15 p.m., here on the Coalition Radio Network. Thank you, everybody, for indulging us tonight, and have a good evening.
And I want to throw one thing in. We will be publishing, if you will, this video this evening. We're going to add to that links to, on the coalitionradionetwork.com website, if you will, the entire text of the, I guess you call it the pleadings, or the briefs filed by both sides, so that folks who want to do a little bit of a deep dive, or any one of the attorneys who watch this show, can find one resource. And that's what we're going to try to do here going forward. And we've done this in the past. We want pleadings, briefs, videos, links. We try to include whatever we can, so that folks, if they're willing to invest their time, to dive in. By the way, we have a simple way of finding us right now, the Coalition Radio Network website. Just simply weaskthequestions.com. Weaskthequestions.com. If you get confused with the radio bit and all that stuff. So, because you know what? We ask the questions. Have a good night, folks.